Welcome, everyone. So this session is intended to be your opportunity to ask questions directly of our excellent panel, who I'll introduce now. We have Rick Marshall, a partner at Katten, Muchin, Rosenman in New York, who just waved. Marianne Pisarri, a partner with Pickard, Dijinis, and Pisarri in Washington, D.C. And Janice Powell, a senior compliance consultant at Core Compliance and Legal Services in San Diego. So they've been following closely with the rule and the questions that have been coming in today. We have received a couple of questions in advance, so I will start with those. And then I'm going to open it up to the audience for you to unmute yourselves and ask your questions directly, or you can always put your questions in the chat. But I do encourage you to speak up. I think it's easier to explain when it's by voice instead of in the chat. So starting with one question we received.
Could I just interrupt with one
sure,
announcement?
Sure.
I don't know if this has come up on other panels, but at the end of the day on Friday, the SEC did publish a list of the no action letters that they're withdrawing because of this rulemaking, which is a very, very long list. And so you can find that at the SEC website, sec.gov, under investment and management. It's right on the homepage for investment management on the right column. And that's been something we've been waiting for, but it's really a gigantic list. Some of us is kind of like losing an old friend. I mean, there's so many letters that we've grown up with that are dead now. It's kind of sad, but just so people know, that research just became available.
Yeah, so we've included that list in the workshop materials. It's item 3H. If you go to the link in the email confirmation, you'll see that is there as well, but you can also find it on the SEC website. So thanks for that, Rick. We've been waiting for that list for a long time. But I wanted to start with a question we received regarding something called LinkedIn Sales Navigator. I don't know if everyone's familiar with that, but essentially you can pay LinkedIn to, I guess, get certain lead generation that you can make certain searches. And I think, Marianne, you looked into that and have some thoughts on whether or not that triggers the new marketing rule.
Yeah, thanks, Laura. I would say it does not trigger the new marketing rule, assuming that I understand the features. So this is what I assume it to be, is that the user, in this case, the advisor, can use this Sales Navigator feature to basically prospect through the membership of LinkedIn. LinkedIn itself doesn't do anything except provide the tool. The tool is used by the advisor to come up with prospects. And then when the advisor identifies prospects, the advisor can communicate through LinkedIn to the prospects, but LinkedIn itself does not do any endorsement. They do not, it's not a system where they match an advisor with clients or clients with an advisor. So in that sense, I would say that this is not an endorsement. The adopting release, if you have a free moment to read 430 pages, says a non-investor selling an advisor a list containing names and contact information of prospective investors typically would not, without more, meet the definition of endorsement. So assuming I've got the facts right, the answer is no, it's not an endorsement.
Okay, thanks, Marianne. So next question that came in, I think there might be a little bit of confusion about the new concept of promoters and whether that applies to current clients, meaning testimonials, or prospects, meaning endorsements. Who wants to take that one?
I'll take. Oh,
go ahead. Go ahead. No, go ahead, Marianne.
The answer is yes. There's a footnote in the adopting release that says it's both. Testimonials and endorsements are both promoters.
Rick, did you want to add anything?
I'm sorry, what I was going to try to focus on the question so I make sure I understand the question. Is a promoter only applicable to non-clients endorsements, or can a client be a promoter testimonials? I guess that was the question, and I guess Marianne has answered that. The question is what makes somebody a promoter? And it doesn't matter whether the person is a client or not a client if their activity is basically recommending an advisor. That's, I guess, the point. They may be regulated somewhat differently, but they're still either providing an endorsement or a testimonial.
Great. Okay, I want to move on to a question about the Fidelity referral channel. Rick, maybe we'll stick with you on that one.
Right. Well, I'm a little bit sensitive here because I haven't been called by Fidelity, but I might be. So I want to be careful about this. But one of the big changes from the old solicitation rule is that the old solicitation rule only applied where there were cash payments. It was very explicit. It was only cash payments that triggered the rule. So where you had non-cash payments, for example, you qualify for certain referrals if you generate a certain amount of brokerage or you provide other non-cash benefits. I believe the way most of these programs work is that you qualify to be on these programs by generating a certain level of brokerage commission through the platform. And that would be considered, therefore, non-cash compensation, which would trigger the rule. So that's a big change from the old regime. So they would be treated as a somebody subject to the, what I would call a solicitor, what I guess is now called a promoter.
Janice or Marianne, anything to add on that?
No, just an asterisk for anybody that engages in these things. This is so different from anything you've ever done before. You really have to change your mindset. And in terms of how you get these brokerage platforms, how you comply with the testimonial and endorsement requirements could be daunting.
Yeah, and just one last piece from me is that, I think you're really going to have to dig into the contracts. What is your contract with, Fidelity or with the custodian that offers a program like this? Because, not knowing what is included in there may inadvertently open you up to some scrutiny that you haven't, dealt with previously. So, digging into those contracts and really understanding what is it that you're getting, how is it paid for, and does it fit into this rule is I think going to be very important.
One of the scariest things for lawyers in the adopting release is that the release said that where a lawyer recommends advisors who send a certain level of business to the lawyer may be a promoter, even though obviously the lawyer's not getting cash compensation for referrals. And that is not an uncommon kind of arrangement. So you have to be very careful about the scope of this now that what makes you what used to be a solicitor, now promoter, what makes you in that category is not limited to receiving cash.
A couple of questions are starting to come into the chat, including how should firms compare what the current solicitation rule requires versus what will be required under the new rule? Are there any resources or recommendations you have?
Well, we have a slide deck. Is the slide deck part of the material? I sent it over.
Yes.
Yeah. I mean, the big changes, the solicitation rule had some significant changes. The biggest one I've already talked about. Non-cash compensation triggers the rule. It didn't in the past. Another huge change is soliciting for private funds. Previously, when you solicited for private funds, you were not governed by the solicitation rule. Now, under the new regime, you will be. And that's a very significant difference. There are other changes which I think are less significant about the disqualifications and also what the contract has to provide and what the disclosure has to say. Those I think are more technical, but the two big ones I've identified, I think really are quite significant.
Yeah, and I think It's important to know what the differences are, but I think people can get themselves twisted up if they're so focused on the differences that they're not focused on what they have to do. So I think we heard in some of the previous panels that a good place to start is take all your current solicitation arrangements, then look, and there's a lot of materials in the workshop binder or the workshop materials that tell you what the testimonial and endorsement requirements are under the new rule. So look at your current solicitation arrangements, but then look at the rule itself. It doesn't matter what the old rule was, because as of next November, that's going to be gone. So look at the breadth, the fact that private, the Mayor Brown letter is going to be gone, private fund marketing or endorsements and promotions are now under the advertising rule. Look at what's going to be required. And then you're going to have to do a gap analysis against what you're doing today. But I wouldn't get too hung up on the specifics of what's changed. I think Rick has named the two big changes, but I would just focus on making sure that you're going to be compliant with the new rule.
I see a raised hand. Christine, do you want to ask a question?
Yeah, thank you. So my question is with regards to the balancing of risk language, specifically with social media, and if we could link where there are certain constraints on providing a full breadth of risk language that pertains to an infographic, let's say, if linking would be sufficient.
Did somebody fully understand the question? I'm sorry, what would be linked to what?
If we could link to risk language that is balancing out an infographic on social media where there's certain constraints on how much language and disclosure we can put on that type of communication.
So you would put something on social media which requires some fairly detailed disclosure, and there's just no room on it for social media. Can you include a hyperlink to permit people to see that? I'll let my co-panelists comment on that. I think that generally that would be acceptable. I think the release talks about the ability to do that, and as a practical matter, there's no alternative. The difficulty you're going to run into is the technical aspects of that. If the hyperlink is readily accessible, then I would think that that should be sufficient. If it's difficult to access, then you might have a problem.
I agree with the link idea, just because that's, you are so limited on social media as to how many characters or how much information you can put out there. I think the challenge may be is it a link, that will take you to a specific disclosure related to that posting, or are you looking at potentially just putting like all of your disclosures for everything that you do on a page and linking to that, so that the person viewing the LinkedIn posting or whatever has to go try to, navigate all these different disclosures and decide which one's applicable. So, I think in a thoughtful approach to putting a link on a page that links to those disclosures, needs to be in such a manner that it is not difficult to find.
So one question I saw in the prior chat was just a basic question about performance. And the question was, is it true that every time you present gross performance, you have to have net performance? Are there any exceptions?
If it's not an advertisement, you don't have to have it. So if you genuinely, well, I mean, I guess there's a difference between whether you're reporting to a current client or advertising. And if all you're doing is reporting performance to a current client, you don't have to present gross. Number two, if you, there's a lot of background, I'm sorry if I get distracted, but if you do a genuine one-on-one, it wouldn't be an advertisement unless the performance is hypothetical, then it might be picked up even with one-on-one. The problem which the SEC cautioned on is that when you have a template that you use over and over again, they won't treat that as one-on-one. They'll treat the template as advertising.
And that's really not a change from prior. That's the way
No.
things do today, because typically when they do pitch books, advisors will have a pitch book with a lot of stuff about a specific client they're pitching to, but the performance pages are the same.
Yep.
So the performance pages there would be the advertisement.
Yep.
And there's a question, does the net requirement in marketing apply to attribution, risk metrics, and supplemental charts and graphs?
Well, it applies to I looked this up. The rule applies only to portfolios. And what you describe, attribution risk metrics, would probably, I would think, referring to the portfolios. So there, it would have to be, sorry. I'm going to have somebody, even though I've got it on privacy, somebody got through to me somehow. But the answer is it would apply to a portfolio. But if you really did have something that was just not the portfolio, but we're going to have to let it go. Somehow when I logged in, I turned off the mute feature, so it's ringing through. My apologies. But if you had just one particular security, arguably it's not a portfolio. The problem is that you would still be subject to a lot of the general prohibitions. So even if it was for one particular security, so a case study, for example, if it's misleading to present the information gross, you probably would have a problem under the general prohibitions.
And Rick, what about if it's a one-on-one template, such as used for prospects? Does it always need to be gross and net?
If it's a template, it's an ad. If it ad, it has to have net.
Another question back to our discussion of promoters. Are intermediaries considered promoters? I'm not sure what intermediaries
I know.
are contemplated.
Yeah, generally, yes, if the intermediary is acting on behalf of the advisor. So, I mean, that's almost by definition what a solicitor is. You send somebody out to intermediate between you and the prospect. I think the adopting release draws the distinction between that kind of an intermediary and somebody whom you hire to help you create an advertisement that you send out. So if you have an agency that helps you, like an ad agency or somebody that helps in the dissemination of the document, but it's actually your document, that person might not be a promoter. But if you're paying somebody to go out and talk you up to clients, that kind of an intermediary is a promoter.
Mm-hmm. And Marianne, what about a situation, a consultant? So you provide data to a consultant and the consultant recommends you. I would think they're not a promoter. They're not being paid by you. They're not acting on your behalf.
Well, it depends. They do use, they talk about where the investor hires a consultant and to help with an RFP with the understanding that the advisor who's chosen is going to pay the consultant's fee. In that case, the consultant is not a promoter, is not and these would all be endorsements because they're not your clients. But I think if you pay a consultant to go out, you pay a marketing consultant, go out and
Oh, sure. I agree. I meant by a consultant, one of these independent professional organizations. The big people who evaluate thousands of advisors and they get hired by big institutions to recommend an advisor. I don't think they would be a promoter, even though they may go and recommend to a giant institution, the Harvard Endowment, hire Rick Marshall. Rick Marshall gives the consultant information, but the consultant isn't working for me, isn't paid
Hello,
for me.
if you can hear me, this is Megan Olson with the IAA.
Megan, we can hear you. Oh, sorry about that. I need to, while we're interrupted, I need to announce the code word, the first code word, which is tree, T-R-E-E, tree. That's your first word. Sorry, go ahead. Was there?
I was done.
Okay. Okay. Next question is a COI, meaning of influence, such as an attorney or an accountant, with no cash payment, considered a promoter and is an agreement required?
Well, I talked about that a minute ago. Maybe if a lawyer, this is right in the adopting a release, if a lawyer recommends advisors who send them a lot of legal business, that may be treated as non-cash compensation to the lawyer and therefore make the lawyer a promoter. How that's going to work in practice, we don't know. That's a huge change from the prior regime. But a lawyer or an accountant, if they recommend people who send them a lot of business, that's indirect compensation. It could be that makes them a promoter.
I think it is probably, unless it isn't. And what I mean by that is it depends on the facts and circumstances. Is it just that you both really like each other, or is there an unstated quid or stated quid pro quo? And I think if you do send business back and forth, you might have a burden of showing there really isn't a quid pro quo. It's just we both seem to like each other and send business back and forth. But there was something in the adopting release about, does the timing of the payment matter, and does it matter if there's a quid pro quo? And it's all facts and circumstances, which is, again, another reason this rule is going to be such a challenge going forward. And just, you know, we started out by talking about all our old friends, all the old letters that are going to go away next November. I think it would be naive to think that this evergreen principles-based new marketing rule is going to answer all the questions. I think we're going to start eventually adding a new crop of guidance, sub-regulatory guidance under this, because there are just so many gray areas. And I also find it interesting that the commission said we're going to take away the letters, but in various cases, they say you might look to the defunct letters for guidance on how you might proceed with a question. So they're going to be gone, but not forgotten. And I just hope that if that's the case, the commission finds a way not to remove them from their website. They can indicate they're withdrawn without eliminating their existence if people are going to still need to look at them.
I think, you know, just from a practical applicability of some of these, you know, circumstances is, you know, the firm really needs to dig into, you know, kind of how the structure of those types of relationships are going to work, and then have, you know, just documented policies and procedures as well as oversight, you know, to ensure. I mean, you know, at the end of the day, we don't know, because some of these are very complicated and things that have never happened before, but the SEC will expect that the firm will have gone through some level of how do we attempt to comply, you know, and in this interim time of where we're trying to figure out what they're going to say and withdrawing letters and how they're treating some of these circumstances, especially where it comes to the non-cash compensation, that, you know, it would behoove a firm to really try their best to develop a policy and procedure and structure around those types of arrangements and how they're going to handle them, and then follow those policies and procedures, because that will be probably the initial crop of deficiencies and, you know, even enforcement if those things aren't considered and looked at.
I'll just put one more observation, the things that lawyers are worrying about. Suppose I'm treated as a promoter with all the caveats we've described. So I'm getting a certain level of business. In exchange for that, I recommend a particular private fund. So now I'm recommending a security. Do I need a broker's license?
So one of our attendees, Catherine, has a couple of follow-up questions. Catherine, you can unmute yourself.
Absolutely. Thank you so much. We are in a bit of an unusual situation in that we have a lot of joint advisory or co-advisory relationships with clients, and wondering, and on the intermediaries question, I think this prompted it, is that will they be promoters? They have a fee, we have a fee. How do we handle that, in that we're both fiduciaries and what kind of disclosures, or are they promoters? Do they qualify? And just needing some guidance around that.
When you say co-advisor, what do you mean? One advises one part of a portfolio and one advises another, or a sub-advisor? What is a
Yeah, so basically what we do is we do all the investment management aspects, and then the advisor does the suitability, if you will. So they select the strategy the client invests in, and we actually invest. We manage the strategies, we perform all the trading, we do all of that. And so they are, it's difficult for me to understand how to qualify that, as in, are they actually a promoter? Are they a partner? Are they now they're some kind of an affiliate, or what does that even look like?
Who appoints you? Do they, or does the client?
Yeah, so we have a joint advisory agreement with the advisor, and then the client signs an investment advisory agreement with the advisor and ourselves. So it's a dual contract, if you will. And then are they considered promoters, and how do we develop policy procedures? Like, how do we monitor? Do we need to monitor? How do we I'm not sure what to do. To be honest.
Who does the marketing? Would the other advisor do the marketing? And basically what they do is they say, if you hired us, we'll hire this other entity to make the investment decisions. Is that how it works?
Yeah, exactly. We produce marketing, advertising materials, we pass to them, and then they pass on to the clients. And so it's kind of like a pass through, and that's why I use the term intermediary, because even we produce these materials for them to use with their clients. And so
well, the materials then are clearly your advertisement. So there's two,
absolutely,
as you know, there's two prongs to the definition. The first one is your communication, direct or indirect. So
yes,
this would be your indirect communication. So all those materials are, I don't really think they're your promoter in,
okay.
I mean, I don't know. Co-panelists, what do you think?
Well, I think if they're, I mean, you could get in some really sticky areas, especially where it comes to potential sub-advisory relationships and other co-advisory relationships.
Yeah, and we have sub-advisory relationships as well. And so I'm just trying to contemplate the full picture of how do we, how do we make everything, doable under the new rule? It's complicated for us because we have a lot of different business models. And how do we do the sub-advisor? How do we do consulting? How do we do our joint or co-advisor relationships? And so how do we classify each of those individual partners?
I honestly don't know. I'd have to think about this and get, maybe even talk to the SEC staff about it. I can see arguments both ways. What the argument for why they might be considered in a promoter relationship is really the other entity.
Statement in there since inception, the fund has never used leverage.
I'm sorry, I couldn't understand that.
No, it's somebody else unmuted.
Kind of mute.
Okay, I'm sorry. But I think the argument that they're a promoter would be that this other entity is basically going out to the potential clients. You don't market to them. The other entity goes out and markets and says, you hire us, you get this other advisor who we recommend do the portfolio management. And I could see an argument that makes the other entity a promoter. I could also see in the sub-advisor relationship, you're basically selling a package. And of course, this is a package too, but I've never thought of a sub-advisor as using the advisor as a promoter. Even though the advisor is usually in the lead on marketing, but I don't know the answer to that. The new rule is principle-based, which means this could come out either way.
Well, and I think it ties back to what Janice said with while we're working through all the gray areas, the best thing you can do is take a position, a reasonable position, and document why you've taken it. And it also harkens back to what I said is we're going to start accreting a whole new crop of no action letters. Because I think this is exactly where you would want to get some staff guidance.
Okay, next in the queue is Trish. Trish, go ahead.
Sorry.
Oh, there you are.
So my question relates to presenting composite performance and whether that's considered hypothetical performance, because no one account, even if they're all managed under the same mandate, would have exactly the composite performance.
I don't think it is. I mean,
Oh.
a composite has been around for a zillion years, and it's just basically a group of accounts that are similarly managed, even though no one account in the composite may be exactly measured or managed the way the composite is, but it's actual performance. So I would not treat that as hypothetical.
I agree.
Great, thank you. I heard on a webinar earlier this week that they were considering it hypothetical, so it kind of caught us off guard.
No.
Thank you.
Okay, we have availability for others to ask questions, so please speak up or raise your hand or get my attention in the chat. We'll call on you. While we're waiting for questions, I did want to get to one about how the new rule will impact web-based fundraising platforms for private funds. Can a private fund still use a web-based fundraising platform to find investors without, I guess, breaching the general solicitation or general advertising parts? I guess they're talking about the current rule. What about verifying accredited or qualified investor status? Any thoughts on how this will affect fundraising for private funds?
Or something, he's meeting with someone.
You want me to speak to it, or somebody else want to?
Yeah, you can take this, Rick.
Okay. Well, in terms of qualifying as an accredited investor, the new rule doesn't change that at all. That's an obligation ultimately of the issuer. And if you want to outsource that to somebody else, which is fine, you just have to make sure that you've done due diligence on them, that they're qualified and doing a good job. But the new rule doesn't affect that. That's a 33 Act issue, and it's not really affected by the rule at all. In terms of the platforms, they qualify, I mean, they get paid, obviously. It's not a charity. They get paid by somebody for something. And most of them are either broker-dealers or they're structured to qualify for an exemption from broker-dealer registration. So I don't think the new rule changes that at all. The question is, to get on the platform, do you have to provide them with some benefit? Many of the platforms are paid not by the advisors, the funds that are in the platform, but by the investors. And in that case, I don't think you would have a problem. If the fund pays the platform to get on the platform, either by cash or some other means, you might well have a promoter relationships, which didn't exist before because private funds were never governed by the old solicitation rule.
Thanks, Rick. Eva, you can go next.
Great, thank you. So a quick question. We have a limited partnership, which is a private fund, but it's within the same strategy. And so as our long only equity strategy. And so it's part of our composite, our GIPS verified composite. I guess my question is relating to that specific fund. We changed our fee schedule. It used to be more hedge fund like, and so we used to charge performance fees. So we now have a fund fact sheet specifically for that vehicle that includes the complete historical net of fee performance, including, you know, the former fee schedule. So the actual kind of net returns of that fund, as well as the gross returns of that fund, as well as hypothetical performance, or what I believe is hypothetical performance of the fund's historical returns assuming our current fee schedule, which is just a flat 1%. We include all of those kinds of one after the other, so they're all in equal prominence in the exact same kind of on the exact same page. My question is does that represent, am I correct in thinking that that represents hypothetical performance, and what should I be thinking about from a disclosure perspective?
So the hypothetical is going back and running what you had with the new fee structure.
Correct.
My initial reaction is it's not hypothetical performance, it's actual investment decision making. So under the new rule, I would not treat it as hypothetical. You're basically recalculating actual performance that was generated by really making investments. And you're just applying a different fee than the one that was actually imposed. I don't think that makes it hypothetical. I thought you were going to ask about GIPs, which is the two hardest things in this whole regime is how do you make it harmonious with FINRA rules? How do you make it harmonious with GIPS rules? And maybe our co-panelists would like to take that one on. That's
Not
a tough
with a
one.
10-foot pole, Rick.
The answer, they're not consistent, and it's a big problem.
One thought, and I'm not quite sure, I'm sort of thinking as I'm speaking here, is the concept of a model fee. When you charge a model fee, that doesn't make it hypothetical performance. And if the model fee, there are two instances in which you can do net performance using a model fee. One is where it's the highest fee charged to the clients that you're presenting to. And the other is where the fee, using the model fee, would not result in higher performance than if you use the actual fee. And I don't know if you substitute the flat 1% for the performance fee, whether you can satisfy those conditions, but that may be one way to look at having to not consider it hypothetical.
So you would have to then you would then have to satisfy both of those conditions. It's not enough to have it just be the highest fee that any investor would pay. Because definitely, you know, we got paid a performance fee, so the historical net performance is lower than this, you know, flat 1%.
No, I believe it's actually the model fee is disjunctive. I don't think it has to be both of them. Let me let's see. It's in the net. Yeah, it's in the disjunctive. So you can reflect the exclusion. It may have a model fee if it's the deduction of a model fee when doing so would result in performance figures that are no higher than the actual fee, or it is equal to the highest. So one or the other. So if it's going to give you a lower performance, I think you could use it as a model fee and it wouldn't be hypothetical.
Wow, that was incredibly helpful. Thank you so much. I really appreciate it.
I hope it's right. No, I think that's the analysis I would follow.
I'm going to give the second code word now. The word is neighbor, N-E-I-G-H-B-O-R, neighbor. And Christine, you can go next.
Thank you, yes. I didn't see anyone else with their hands up before, so I thought I could ask the second question. So this is regarding risk language again. In our pitch books, where they may be 60 pages long, with regards to risk, I understand that just having one risk disclaimer at the end may not be sufficient, as it's not really fair and balanced. But is there really a requirement to have each time we list a benefit on a slide for, let's say, preferred securities, that we then need to balance out that slide with the language? Or is there some sort of every so many pages we maybe need to include risk language, or maybe up front in the pitch book just a disclaimer of relevant risk, or is it really just a facts and circumstances analysis?
I think it's going to be facts and circumstances. You know, again, is it going to be misleading to not have it? You know, close by, or how often you should list it.
Yeah, I think that the current practice or the standard practice of putting everything you want to put with a footnote saying, see page 12 or page 30 for important disclosures, and then putting 2 pages of 7-point font risk and every other kind of disclosure, I think those days are done. But at some point, putting all the disclosure every single time, the adopting release talks about, saying a benefit and putting 1 benefit and 1 risk disclosure, and then maybe putting the other one someplace else, but they frowned on the idea of putting all the positive things in one place and then referring people to negative things. So I think you're going to have to do a balance, because if you take it too literally, you're going to have something that's completely unreadable.
Thank you.
Who would like to go next? No one's in the queue. Actually, a question did come in on a prior panel that didn't get answered, and it was, they know that you're not required to pre-approve materials anymore, but as a best practice, do you suggest that compliance pre-approve at least high-risk materials? I'm not sure what would make it high risk, but at least pre-approve some things.
I think, just, from a practicality standpoint, if you have been reviewing compliance, related marketing material, or having a compliance review in marketing materials previously, that you all of a sudden go to, well, it's not required, so I'm not going to do it. I'm only going to review half of them. A regulator might say, well, what changed and why? That might be problematic.
Yeah, I think it's just supervision 101. If there is something that you think is high risk and nobody's looking at it before it goes out, that's a really bad idea.
When they took out the pre-review requirement between the proposing release and the final release, they didn't intend to say you can do whatever you want and just hope it turns out right. So high-risk materials should be pre-approved, whether there's a requirement to do that specifically or not.
Eva, back to you.
Thank you. Going back to the question about the fair and balanced disclosures. So I think we certainly are faulty of that, of putting please see important disclosures at the end of this presentation. So is the sentiment or the comment then that after we include our performance page, or the page that has our risk return statistics versus the universe, for example, those positive attributes at the bottom, including the kind of past performance is no guarantee of future returns, and investments may result in loss, those disclosures at the bottom of that page to go along with those performance charts and those risk charts?
Well, they took out the specific Clover type. There's no specific disclosure that you have to make. But again, I think this gets back to everybody's going to have to find some sort of a reasonable compromise between putting every disclosure every time you say something, and don't be hard on yourself. Everybody or a lot of people, I think it's standard to put all the disclosures at the back with something, either a hyperlink or a legend on the specific page saying look at page whatever for disclosure. So I think that's what everybody does, but there are so many possible ways this could shake out depending upon what it is you're advertising and what it would take to make it fair and balanced.
I think what's going to happen a lot more with this is the SEC is going to really focus on location and prominence and actual related disclosures. So when they talk about inline disclosure, they want the disclosure that's actually relative to what it is that you're disclosing. and making sure that, it's enough that the viewer or whoever's reviewing this and making a determination whether or not to do business with the firm or to continue to do business with the firm is, are they going to be able to make that informed decision based on the information you're providing? I mean, I recall in my early days of being a CCO where we did just a whole, page of standard disclosures that we stuck on every presentation or whatever, whether they were relevant or not. And actually had somebody ask me, why do you do that? I said, well, we're just trying to disclose everything. And they said, well, even too much disclosure that's not relevant can also be seen as being misleading. So I think that's kind of where the new marketing rule is going in terms of providing that disclosure that's in line and relevant to what it is that needs to be disclosed.
Thank you.
A lot of this goes to the whole problem of this is principle-based rulemaking. And in the past, the no action letters created kind of a whole bunch of do's and don'ts. Not in every area, but in a lot of areas. We're kind of back to sort of, be fair, be just. And how that works in practice is difficult to give details on.
Try to get through the questions in the chat that are remaining. So the first is, if you prepare an investment proposal tailored for a single client that shows hypothetical performance, what, quote, diligence has to be documented now?
Well, you have to determine that you have to identify your audience, which is easy to do, and you have to determine that the hypothetical is relevant. The hypothetical requirement applies to one-on-one. How you determine that it's relevant is sort of the $64,000 question.
Yeah, I guess the one time you wouldn't, or I guess 2 times you wouldn't have to comply with the rules if the client asks for the hypothetical, but asking has to be really asking. You can't wink and nod and say, you really want to see this, don't you? And then a one-on-one with a private fund is accepted from the hypothetical requirements. So yes, you have to decide it's relevant for that audience. You have to identify, the why and who the audience is. And obviously, who the audience is here. You have to explain the criteria that you used to get to the hypothetical performance and the risks and limitations in the hypothetical performance.
Do risk return stats need to be net of fees?
Well, return is performance, I assume, in an advertisement, so it would have to be net of fees.
We send a weekly note to our private fund investors and often end with a comment on how the private fund is doing for the month. For example, the fund's up slightly for the month. Can we still do that under the new rule?
Yes, if it's a communication to an existing client that doesn't offer a new service, it's not an advertisement.
And then there were 2 comments about the pre-approval point. One is, one person says that they do have every single advertisement approved by compliance just as a good practice. And another comment was, I think just to clarify the question, which was, they were told that several advisors only approve high-risk materials. They were told that it's industry practice to distinguish high risk from low risk, and they're just asking if we've ever seen that practice.
I've seen both practices.
I think if the volume is quite high, you can't possibly review everything.
Right.
I think it goes to policies and procedures. You make a determination. What do you deem to be high risk as a firm? It may be different than, somebody else in the industry, but what do you deem to be high risk, and what are the requirements for review? So I think it goes back to policies and procedures.
Yeah, and I think one thing you might think about in the policies and procedures is having some guardrails on what's high risk, what's not high risk, and approve
think Marianne froze. Okay, I'm going to try to get one more question. Is all fund-related performance assumed to be net of fees? Janice or Rick, can you take that?
What do you mean by assumed? I mean, first of all, mutual fund performance is exempt. When you say fund, forget mutual fund. For private fund, I believe it would have to be net of fees if it's in an advertisement. So more than one to a prospective client. Reporting to the existing investors on what's going on with their investments is not an advertisement, so it's not governed by the rule.
Eva, do you have something quick? We only have a minute.
Yes, and if we don't get to it, that's fine. We currently have a fund that has typically had very high cash balances historically. And so for some institutional clients who've been coming in, they've been asking about us offering one with either lower cash or no cash. And so we've run kind of historically what the equity only portion of the fund, that return has looked like, their risk statistics, volatility, et cetera. I'm assuming that's considered hypothetical performance.
Correct, that's hypothetical.
Okay, thank you.
All right, we're going to end it there. Thank you, everyone. Just a couple of announcements. Please complete the evaluations you get, especially if you're seeking continuing education credit. You need to fill out that evaluation. The continuing education section's at the bottom of that page, and you'll submit the code words you collected today. You have to submit the evaluation and code words by Monday, November 29th. Also, don't forget to join us 2 weeks from today, Thursday, November 18th, for part 2 of these workshops. That day will be devoted to ESG and will run from 1 p.m. Eastern, I think until 4 p.m. We'll have 3 sessions on ESG investing. And lastly, just a reminder that we will have our annual compliance conference in March 3rd and 4th. We will be in person. So we hope to see many of you there. Mark your calendars for March 3rd and 4th, 2022. We're going to spend a lot of our time there on the marketing rule. We're going to have one general and 3 breakout sessions, all devoted to marketing. So thanks again for joining us today and bearing with us with the Zoom issues. And we hope to see you again in a couple of weeks. Thank you, Rick, Marianne, and Janice, for a fantastic job fielding these lightning round questions. Take care, everyone.